Ma'am, shall we begin?
Yes, please.
Ma'am, shall we begin?
Yes, please.
Yes, please.
Kautilya, the writer of Arthashastra, wrote, "One destitute of wealth is not destitute. He is indeed rich if he is learned, but one devoid of learning is destitute in every way." A pleasant evening to one and all. I, Nikita Chandelier, on behalf of the entire team of LexCom, the corporate society of VSLLS WIPS, welcome you all to the day 2 of this national workshop on Insolvency and Bankruptcy Code 2016, conducted by LexCom in collaboration with Career Counseling, Training and Placement Cell VSLLS WIPS 10. I am extremely grateful to the dignitaries of our event, Professor Venkat Rao, Sir Chairperson VSLLS, Professor Subha Rao Sir, Professor Emeritus VSLLS, Professor Rashmi Saltrika Ma'am, Dean VSLLS, and Professor J. Ravindran Sir, Associate Dean VSLLS, WIPS, for giving us this opportunity. This event is illuminated by the light of knowledge from our eminent panelists, Mr. Dhrupad Vaghani and Dr. Charu Mathur. I would also like to thank the faculty convener of LexCom, Assistant Professor Sonia Mannan, and faculty convener of CCTIP, Assistant Professor Hani Ma'am, and Assistant Professor Priya Bhatnagar Ma'am for their unconditional support throughout the event. I would also like to extend a hearty welcome to all our faculty members at WIPS and all our attendees today attending through the Zoom call or streaming live on YouTube. Without further ado, I would like to request the presence of Assistant Professor Priya Bhatnagar Ma'am, Faculty Convener of CCTIP, to this digital podium to deliver the welcome address to our esteemed panelists and attendees for day 2 of this national workshop. Over to you, ma'am.
Thank you, Nikita. On behalf of Vivekananda School of Law and Legal Studies, WIPS, I, Priya Bhatnagar, convener of Career Counseling, Training, Internship and Placement Cell, VSLLS, welcome you all to the 2-day national workshop on Insolvency Bankruptcy Code. We meet again to the day 2 of the national workshop, and again today we have a set of distinguished speakers amongst us. Mr. Dhrupad Vaghani, Legal Counsel at Economic Law Practice and Advocate on Record, Dr. Charu Mathur, Supreme Court of India. We hope to take away from today's session the first-hand expert knowledge and applicability of the Code 2016. Once again, welcome you all. Thank you.
Thank you, ma'am, for addressing the gathering. I feel honored to invite our first panelist for the day 2, Mr. Dhrupad Vaghani. Sir is an associate partner in banking and finance and IBC practices of economic laws practice. With over a decade of experience handling several bank and finance transactions, including standardization of documents for various financial institutions, onshore and offshore syndications, consortium financing, title due diligences, and financing of NBFCs by banks. It will be our honor to invite you to enlighten the gathering with your words of wisdom, sir. I would like to hand over the mic to you.
Thank you so much. Thank you for your kind words. And hello, everyone. My name is Dhrupad Vaghani, and I'm an associate partner with Economic Laws Practice. So today I'll be taking you through what is Insolvency Bankruptcy Code and the corporate insolvency resolution process under that. I'll screen share my presentation, which I've prepared. So it's visible.
Yes, sir, it's visible.
Just a second. So what is Insolvency and Bankruptcy Code? So prior to Insolvency and Bankruptcy Code, there were several different laws which were there in place dealing with different individuals, entities under different verticals of practices or heads that you can call it. One was SARFAESI, where any lenders can come forward and take the assets and sell it and recover their dues. Another was the debt recovery tribunals, where any debt more than 10 lakhs, which has been now substituted to 20 lakhs, lenders, financial institutions can take an action against people who have defaulted on the loan. So these are practices, and there was obviously a defunct law which is called BIFER, which is also repealed now under the practice of Insolvency and Bankruptcy Code. So what is it? IBC? It's a codified law where all different parts of the laws have been put under one and been treated as one act or one consolidated code, where it deals with insolvency and bankruptcy of an individual or an entity or a partnership firm. Entity, I mean a company or an LLP. So insolvency and bankruptcy code deals with that. So what we'll just initially understand the intent and the preamble of the code, why this code was enacted in 2016 and what was the purpose of the code. So the intent of or the preamble of the code says this act is to consolidate and amend the laws relating to reorganization and insolvency resolution. The more important here is the insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner for maximization value of assets of such persons to promote entrepreneurship, availability of credit, and balance the interest of all the stakeholders. I frankly would want to just inform everyone that this is the purpose of which the entire code has been prepared, and that's it. That is the intent which we have to follow throughout whenever we are practicing, as part of what I have at least practiced throughout my last 4 years of IBC. Because here it's not only the financial creditors who are trying to take away the entire money, but we have to understand why the financial creditors are getting the majority of the chunk, and why it's not being following on to the other side of the creditors, or the other side or other creditors after that, which is the operational creditors, which Supreme Court has also dealt in the Swiss ribbon matter, where they said that there is an intelligible differential between the secure creditors and the unsecured creditors. And there is a very nicely Supreme Court has clarified the position why it is not only, and even when a financial creditor, because most of the time or the COC will consist of a financial creditor or an institution, will not only deal with their interest, but have to also balance the interest of all the stakeholders. So once again, I'll just read it out. It says it was to consolidate and amend the laws relating to reorganization insolvency of a corporate person, partnership firm. So as of now, the IBC has already only been they have done it for corporate persons. Partnership firm, they have not started as of now, and they have only notified to the extent of individuals, to the extent of the personal guarantee, which was done somewhere in 2018 December, and in a time-bound manner. So time-bound manner is very important, because in between there was an amendment somewhere about a year back where they had increased the time from 270 to 330 days, and they said it mandatorily has to be finished within 330 days. But even in that, the SR Steel matter, the Supreme Court has said that they have struck down the word mandatorily, because at some point of time, it's like in a situation where COC is taking a time to decide, and my 330 days over doesn't mean that my resolution should not go through, and the company should go to insolve or to liquidation. That is where even in the Swiss ribbon judgment, Supreme Court has very rightly laid down that liquidation should always be the last resort wherever there is a resolution. So under the prior regime, obviously there were different RBI mechanisms for restructuring, and restructuring of a company which is under stress, not obviously which is company which is bound. See, there's a very thin line between a company which is being wound up, liquidated, or a stressed company. So RBI had various mechanisms of CDR, SS4, where there is a change in ownership and change in management, which is obviously, this is the same thing which is coming under the practice of IBC as well. And that's the reason IBC and RBI has struck down all those mechanisms, and they've put it under the IBC guidelines. So innovative judgment obviously says that yes, IBC is a time-bound, it is an exhaustive code, and what is the intent is that it was to reorganize and amend the existing laws. And that is what, when I just started saying the Swiss ribbons versus Union of India, made it very clear that what is being sought to be achieved by the code is the primary focus of the code is to ensure revival and continuation of the corporate debtor. See, here we are not saying that the corporate debtor has to die. obviously they have defaulted. There is a default, there has been a debt which they have not repaid it, which will deal it in the subsequent slide. What is the debt, what is the financial debt, and the types of debt, and who can initiate IBC proceedings. But what is important that it's not the company should die. And in a very nice, we have seen one example where there is an entity. That entity was in a business of A. They were doing A, and which was a defunct business, which was into printing business. There was a company which was B, which was planning to take over company A, but the B was into some other business. They was into some other technology. They had submitted a resolution plan which was approved by the NCLT. Then obviously which was subsequently upheld by the NCLAT as well. What the NCLAT and the NCLT had in their ruling said that it's not the company has to die. It is the continuation of the company as a corporate debtor, not in the business. Because even if you look at the CRP regulation, which will deal with it subsequently, it says you can always come up with a change in technology. There was an example during the open court argument when even the technical member had said that, let's take an example of Kodak. Kodak obviously were into the business of the film, which have now come into digitalization. Obviously, people are not started using phones for clicking pictures. No one taking pictures, those getting it converted into photographs and all in a hard copy manner. So it doesn't mean that the company has to still continue doing the same business. I can always take the company do this business, but the important is the continuation of the corporate debtor. So yes, that is what the intent of the code that we just dealt with. So the important aspect and the main thing that we have to understand at the IBC is three important aspects: that there has to be a debt, there has to be a default, and whenever you file an application under whatever section 7, section 9 or 10 that you will deal with it separately, is there has to be a default by the corporate debtor that I have paid a certain X amount. That can be a different whatever, it can be a loan, or it can be kind of even in the new judgment where Supreme Court has that even if a promoter or shareholder has given a money for the revival of or for the continuation of the corporate as a going concern, that can also be treated as a financial debt. So what is a default? Default means a non-payment of debt when whole or any part of installment or amount of debt has become due and payable and is not paid by the corporate. So this is very important that the amount has to become due. So because in one of our case, what had happened was there was a financial creditor. Obviously, the company was into CIRP, but there was a different financial creditor whose penal interest was only due after the company got into CIRP. And unfortunately, the company, the virtual IRP had admitted that amount. So the NCLT in that case said that since the amount was not due and payable, this cannot be treated as a financial debt. So what is important that there has to be a default and there has to be a debt. Now, initially before the COVID and 2020, when a lot of things, obviously things have changed after that, the amount which was required to be for filing any insolvency petition was to the extent of 1 lakh, and it could be filed by anyone. So even an employee or who's also treated as an operational creditor, if he is due more than 1 lakh, can file an application for initiating corporate insolvency resolution process. But now this has been subsequently modified, which have now been increased to 1 crore. But there, obviously, once COVID came in and there were a lot of interpretation issues, whether this circular or the notification with the central government had come out with, will it be a will it be in retrospective effect or a prospective effect? So obviously, different courts, even the high courts have laid down that any notification issued will always be prospective, cannot be retrospective. So to that extent, all default prior to 24th March 2020 will be to the extent of 1 lakh. And post one, there has been an increase in the cap of 1 lakh to from 1 lakh to 1 crore. Now we'll see what is a financial creditor under the IBC. What does it mean? So financial creditor under IBC means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. Now, so what does it mean? So it says that it has to be a financial debt. Now, financial debt, obviously we'll deal with it separately, but who all can be a financial creditor? So after the Chitra Sharma judgment, where home buyers initially were not, or there was no clarity whether any person or any individual who has purchased a house and where the developer has not completed the project, what happens in that situation, whether that home buyer can, or an allotee. Home buyer was a terminology given under the judgment, but the IBC has a reference of allotee. whether such allottee can initiate IBC proceedings. Yes, they can now, but there has to be a certain threshold that they have to meet, and they are now treated as a financial creditor. Trustee or an agent to act as an authorized representative for all the financial creditors. So this is where I have issued certain debentures. So debenture under the Companies Act is treated as a debt, and in most of the cases where debentures have been issued, there is a debenture trustee. So that is where this terminology comes in, which says that a debenture trustee or an agent acting as an authorized representative can initiate IBC proceedings as a financial creditor. Obligor, co-obligor was a very nice concept, which was obviously which came in after the first consolidation order, which was passed by the NCLT Mumbai bench, where under the Videocon matter, Videocon group companies, where in that situation, what had happened was Videocon group company was a primary obligor of a loan which was taken by different company or different lenders, and their group companies had acted as co-obligors, wherein they agreed that if in case the main prior or main obligor defaults in making any payment, will be also treated as co-obligors, which is nothing but as a primary borrower. So if you would have looked at the consolidation order, every entity, which is the 13 group companies in their books, they would have shown 25,000 crores of debt outstanding, which even if that company would have not directly lent from those lenders. And in the Nikhil Mehta and Sons judgment, where it was a very nice question of law, which NCLAT had held, was where assured returns under a law or under a transaction where there was no direct lending. It was an assured returns where if tomorrow that builder had or a developer had to provide a certain flat and within the period of X days did not fulfill his condition, but that in that case they had an assured return where if it goes beyond that period, every month I'll give you interest. So NCLT had not treated them as a financial creditor, but the NCLAT reversed that decision and said that yes, if there was a consideration for time value and money, and in that case will be treated as a financial creditor. Now, what is the meaning of financial debt under the code? So financial debt, obviously, it means a debt along with interest, if any. Recently, in one of the judgment, also Supreme Court and NCLAT said that interest is not something which is mandatory. It can be, or it cannot be. But it doesn't, if there's no interest, that it's not a financial debt because they're heavily relied on the word if any. And it says which is disbursed against the consideration for the time value and money and includes A, B, C, D, E, F, G, H, I, J, whatever, A to I. Now, if, for example, if it doesn't fall under A to I, but if it still there is a time value and money involved, like in, for example, in one of our cases that we've seen that there is a CCD which is issued, which CCD is nothing but a compulsory convertible debentures, which after a period of 2 years under the Companies Act, it has to be mandatorily be converted into equity. But that conversion is never triggered. But under my books of account, it is still showing me as a long-term debt and also as an equity. Whether that can be treated as a financial debt, yes, NCLT in one of the judgments have been said that they fall under the category of financial debt because anything debentures are nothing but a financial debt. So moving on the next part. So obviously this is what it deals of financial debt. Obviously there are other heads of an operational creditor, where there are any goods or services which have not been paid under a particular invoice can initiate IBC proceedings under Section 9. And even an employee, as I said, or a workman whose dues have been outstanding and have a due which is more than 1 crore post 2020 and 1 lakh prior to 2020 can initiate IBC proceedings. And a corporate applicant where a corporate debtor itself initiates an application under Section 10. Now we'll deal with filing of an application under Section 7. So what is important under Section 7 is that your debt should be clear, because under the innovative judgment, it is very important that your application has to be completed. If it is incomplete, your application is non-maintainable. And if the application is non-maintainable, the NCLT cannot pass any orders for initiating corporate insolvency resolution process. Though the Act says within 40, or the court says within 14 days, practically it doesn't happen because obviously you want to the reasons are filing cases. There's a backlog and there are different issues to the extent of now COVID, where the courts are not functioning properly to the extent where only, and a lot of members have now retired where there have been reappointment. But yes, things are moving and things are happening at NCLT level also as well. But coming back to the filing of an application, so these are the key elements which have to be there under the code for initiating any application, that there has to be a debt should be clear. And how you can identify that there is a debt, there has to be, or so for example, I'm filing an application. So and what how can I prove my debt? So there will be a document to the extent that I can say that okay, there is a sanction letter, there is a loan agreement which I have as a borrower would have signed it with the lender. Now that is a debt that you can identify. Hello.
Sorry, so there was an issue.
Yeah, no problem. So what coming back to what the key elements of filing any application. So as I said, as I just said that the debt should be clear and it can be identified on the basis of a particular document, and the loan has to be recalled and accelerated. And so obviously, and just to add in, debt should be clear would also involve a financial statement. So that is where you'll be able to say that yes, I have given a particular loan. Financial statement could be a bank account statement or a books of account, where it says that I have given a particular loan, that loan has never been repaid and it is not reflecting in my bank account statement. Loan has to be recalled because this is very important. Without a loan being recalled, the loan is still not crystallized into the books of the banks or any financial institution. And in light of the innovative judgment, the application has to be complete. And now, considering the PG and CG regulation coming into effect, the bank should identify whether there is any personal guarantee and whatever the action is required to be taken has to be initiated accordingly. So these are the obvious, as I just said, that who all can other application filed by other than the financial creditors, operational creditor, and the corporate debtor itself can do it under section 9 and 10. I'll deal now with post-admission because this is important in light of the CIP, which is what the national workshop is about. What is corporate insolvency resolution process? It's a process where once my application has been admitted by the NCLT, and how you will have to now in a time-bound manner, which is what you'll have to stick to the intent of the legislature, which has been laid down, where I have to maximize the value of the assets, balance all the interests of the stakeholders, and try to revive the corporate debtor as a going concern. Now, going concern obviously does not mean that I have to, as I just said, that it has to be the same business. I can obviously get into change in business dealing in light with regulation 37. So what is important is that once my CIP process starts, if NCLT admits on that day when the admission starts, there is a moratorium which has been allowed. That means from that day onwards, no suit can be continued or be instituted against the corporate debtor, or there can't be any kind of a security interest can be enforced or be collected, because the purpose of the court and why this is the moratorium kicks in is that if I am buying any entity as a resolution applicant, I would want to see what all assets are there and what all assets can be taken over to start that particular business. If every lender starts dealing or enforcing their security interest, I will never be able to bid for a company, because the whole purpose of reviving the corporate debtor could be in most of the cases is having the assets on for which or whatever the requirement of starting the corporate debtor is a going concern. So more important, once a company, the NCLT passes an order for admission, moratorium comes in and an appointment of IRP happens. Once an IRP has been appointed, a public announcement is being issued. So why this public announcement is there? To obviously tell to inform all the stakeholders that yes, now the process has started. I am now the person who's going to be in charge of the corporate debtors. The suspended directors are obviously the powers of the directors have been suspended, and which is now vests with the IRP. And I have to collate all the claims which have been there against the company to see what all claims are there, verify all the claims, and put it as a part of the list of creditors, so that when the resolution applicant comes forward to take charge of the company, they would want to understand what all debt that can be dealt under the resolution plan. So once that the public announcement is issued, the IRP's duty is to take custody and assets, the custody of all the assets, in order to understand that yes, these are the assets that have been part of the corporate debtor. And once the claim comes in, verify all the claims. And once my verification happens within a period of 30 days, I have to constitute a committee of creditors. And committee of creditors is where all the financial institutions would be. Obviously, there are different different understandings where if there are no financial creditors, then who all can be part of the CoC. It will be obviously top 18 or 12, 15, 10 to 20 of your operation creditors. There are different permutations, combinations to that extent. So as of now, we'll not get into too much of details on the CoC. So once the CoC has been constituted, I have to do my first meeting within a period of 7 days. And in the first meeting of my that happens of my CoC, I have to ratify my appointment as a resolution professional, or sorry, not ratify, I have to get it approved, and or you put a voting for replacement of an IRP to a new RP. So once either if the CoC decides, which is a 66% voting item, where at least majority of the lenders have to vote upon whether you want to continue with the same IRP as an resolution professional, or you want to change the new RP, change the IRP with the new RP. For that, to that extent, I have to file an application which will get subsequently approved by an NCLT. So once that happens, once the appointment happens, the primary the powers of the resolution professional is to invite, and obviously to take custody, and all of that is still there, because that will still continue, that I will take control of the charge and assets of the corporate debtor. But intent of this, the purpose of the intent is to, or the main power of my the RP is to invite resolution plans in light of the evaluation criteria, or the criteria or the eligibility criteria approved by the CoC. Why this eligibility criteria is important is that today I don't want any person to come and bid for, or obviously the 1,000 applicants, which there is no credibility of that person to take over the company, and cannot and the company as a going concern cannot be taken after 2 years down, or cannot be treated as a going concern after 2 years down the line. So obviously, because the main intent or the reason of the thing is to see whether the company or the resolution plan is feasible or viable. Because why it has to be viable? Today I say that my book says that I have 100 crores, and that where that money comes in, I have no head or tail on in my business. And next year, under the resolution plan, I would have given a deferred payment of 3 years, 4 years, 5 years. And after 2 years, I don't have the viability to pay that amount. So obviously, it is important that this credibility is there once my resolution plans have been invited. And once the resolution plans are being invited, I have, as an RP, it is my duty to present all the resolution plans which have come for the deliberation of the CoC. Why that language all is there under section 25 is very important, because it says that only it should not happen that I am selecting certain plans and trying to favor, or you are only giving a plan which has a higher, better monetary value. But today that person may not have a better monetary or viability in terms of repayment, which that other person would have it. So that is the reason it is important as an RP to present all the plans. And once the plans are being presented, RP can only put up the plans for voting which are in compliant with the code. So now what are the plans which are compliant, which we'll deal with it separately, but before dealing with that entire process. Now coming back, when the resolution professional invites resolution plan, before that it is important, very important for the resolution professional to prepare an information memorandum. And what is information memorandum? Nothing but it is an information which contains all your details about the company, which is right from your list of assets, list of debt, your whatever outstanding related parties, non-related parties, your workman dues, your existing litigation, your material litigation, everything is covered part of it, so that as a resolution applicant, when I'm participating in that CRP process, it is important for me to deal with it, that how I'm going to deal and dispose of or pay the creditors under the provisions of the code. Now, once the resolution plan is being submitted to the CoC, the CoC will obviously, in light of section 30, which we'll deal with separately, where it says that whatever can be decided at the time of distribution. On that basis, CoC will decide on the resolution plan and put it up for voting, where 66% of voting is required, which is nothing but majority of the lenders have to vote in favor of the resolution plan. And once the plan is being decided, as an RP, the resolution plan will be submitted to the NCLT. And NCLT will obviously, in light of various judgments, even in the SR judgment, that they can't go beyond the powers which have been there under section 30, where they have to only see whether the plans are compliant in accordance with the code or not. And even now in the very recent judgment in EBIX, Singapore, they say that we can't even put any conditions before before the RA whether they want to consider. In past, we've seen in a lot of plans where the NCLT would go back or even the last judgment in the Jet Airways also, where NCLT requested the prospective resolution applicant to consider making payment to the operational creditors, whatever the deposit holders, whether rightly or wrongly. But now, in light of the recent judgment, they can't even do so. And once the plan is approved, there is a monitoring agency, and the plan is being implemented accordingly in light of the plan. Now, impact of moratorium, as I just told, is why this we have already done it. So, whole of committee of creditors is important because once my resolution plan is being put up for voting, why CoC has to consider and balance out the interest of all the stakeholders. So, pursuant to the public announcement of CIP by the IRP, a person claiming to be a financial creditor other than a financial creditor belong to the shall submit claim with proof to the interim resolution process or whatever. The existing of debt to the fund may be proved on the basis of a document set out. So when I'm filing a claim, what is important is that I have to prove my existence of debt, which is what the language under the regulation says. And how you can prove an existence of debt is that I should have a financial contract along with a financial statement, or if I have an order by a competent court directing or mandating under a payment under the order. Once a claim of proof is submitted within the public announcement, the IRP within a period of 7 days have to come back with a claim. Now, we've seen in various instances that there is a period under the regulation say that you have to file your claim within 90 days. But in most of the cases, I have like at least whatever accounts that we've handled till now, we've seen claims coming on till the time the resolution of plan being put up for voting, and even after that. Obviously, when the regulation says that it has to be within a period of 90 days, but there have been various judgments which have been laid down by NCLT and NCLAT. It is that period, whatever the 90-day period is being mentioned, is not mandatory, and it is directly. Nothing which if I'm missed out on the date doesn't mean that my claim is extinguished or it is barred by limitation. This is not a limitation which is barred under the Limitation Act. This is a period which says that I have to make the payment within that period, and if I don't, I can still obviously file it till the time my resolution plan is approved. But once my resolution plan is approved, is where my clock stops ticking, and my claim obviously does not, in light of whether my resolution plan gets approved or rejected. If it gets approved, all my claim extinguishes on the basis of the SR judgment, where it says that it's a fresh slate that the company gets it when the plan gets approved, because you don't want any kind of a claim popping before a financial credit or resolution applicant is taken over and dealing with that issue most of the time. So once my claim gets, whatever my resolution plan gets approved by the CoC, that time it stops where I have any dues against the corporate debtor. Now, coming of filing of claims, this is not much that important. But constitution of CoC, I just said that once my CoC, the claims have been invited and collation of all the claims received after the corporate debtor and determination of the financial, the IRP has to constitute CoC. The CoC shall comprise all financial creditors of the corporate debtor. Financial creditor or the authorized representative. See, authorized representative term is being used is where you have 100 allottees. You can't have all the 100 allottees sitting in a CoC and creating a complete confusion during the any kind of deliberation which is happening on various aspects under the resolution process. So that's the reason there is an authorized representative which will represent behalf of either it can be for the allottees or it will be on behalf of the financial on behalf of the fixed deposit holders or debenture holders, where a debenture trustee will be representing as a financial creditor on behalf of the allottees and your debenture holders. It is important to note that if it is a related party, so related party could be your suspended directors or any promoters, or even if, for example, a group company has kind of given an ICD, so intercorporate deposit, where one company has given a loan to another. In that case, what had happened is that related party will not be represented or participate or have any voting right. Now, there is a very classic example where these entities where they try to have a loan which is given prior to the CIRP or any intercorporate deposit without any documentation. And once the documentation is not there and they assign such loan. So that, for example, there is A and B. B is a corporate debtor and A is a group company. A has given intercorporate deposit to B. Now, if A prior to be filing any financial institution initiates any proceedings against B, A assigns this loan to a new entity just to get that claim of having said that now I'm not a related party, and that new entity will now be sitting in the voting in the CoC and will get voting rights. There is a judgment from NCLAT. It says that even if such kind of an activity or an assignment that you have done just to get away from the voting this thing or the related party tax, in that case your right as a related party will still continue, and you'll not get any right of representation, participation, voting in a meeting of the committee of creditors. Now, subcommittee of CoC is a concept which is very peculiar, which comes in a situation where there are 15-20 lenders sitting in a CoC, and there is a resolution applicant who is there, and they would want to deliberate on the resolution plan. And not frankly, in most of the CoCs we've seen that only few of the top lenders try and negotiate or deliberate on the plan. So they kind of create a subcommittee of CoC where out of a top 6 lenders having a majority of share will come forward and discuss all these issues. But this subcommittee of CoC is not a constitution kind of created. It is only kind of for the purpose of running the business or to decide on an administrative nature, but cannot be delegated to any person and will not have any voting rights. So any voting rights being decided will not have bearing on the others. And the CoC subcommittee cannot kind of have a voting right for taking any decision during the CRP process. This is also being discussed in the SR matter judgment, where they said that the powers of the CoC under 21 age in respect of the matters which are vital bearing on the running of the through an administrative nature shall not be delegated to any person. This subcommittee can only be purpose of taking only or deciding, not taking any decision, but can obviously deliberate on behalf of the other members. Now, appointment of resolution, we've already done it in the previously. So, role of a resolution professional, as I said, that it is even under the SR Steel judgment, the responsibility of the RP is to manage the affairs of the corporate debt as a going concern during the corporate insolvency resolution process, appoint and convene meetings of the CoC so that they may decide upon the resolution plans, and collect, collate, and finally admit claims of all creditors which must be examined for payment in full or in part or not at all by the resolution applicant be finally negotiated by the CoC. So in with respect to point number C, the under the SR Steel judgment, if you have noticed, the Supreme Court has laid down the roles and responsibilities of a resolution professional. What the Supreme Court has said that once an RP has been appointed, he is merely a verifier of the claim. He is not an adjudicator. He cannot adjudicate on a claim. For example, I'll give you an example. What it says is that there is a resolution professional who's invited claims, and there is a financial creditor, a purported financial creditor who has submitted a claim. It says that I have given a loan, I have assigned it, and I have this particular document to prove that there is a financial debt. Now, as an RP, I will only merely verify whether those documents or whatever in light of the regulations are correct or not. But I will not get into the role whether this document is correctly, properly done it or not. Like, for example, the document is not stamped properly or is understamped or has not been registered, where a document like an assignment deed, which is mandatory to be required to be registered, is not registered. I, as an RP, cannot get into the role of an adjudication. I will merely verify in light what it is there and will either admit it or I can't even reject it, because SR Steel judgment very clearly said that again, you're still not an adjudicator, so you can't reject the claim. You put it as a contingent liability, or you admit it, because that is which is a claim which is crystallized. That is where an admission comes, or it's a contingent liability where my claim is not be able to crystallize and I'm putting as a liability which is contingent in nature. Now, once my verification of one of that happens, meeting of the CoCs have been from time to time will have to be convened by the resolution professionals, either in person or nowadays through, because of COVID, it's happening through Zoom or through WebEx, which is nothing but an electronic means. All meetings of the committee of credit shall be conducted by the resolution professional. So in all of the meetings, the RP will always be the chairperson. So in various questions, we have been asked by the CoC that whether can some other person in the absence of resolution professional can take it? No, because it has to be chaired by the resolution professionals. A resolution professional will convene a meeting as and when he considers necessary, and shall convene a meeting if request to that effect is made. So here an important circular IBB had come up, or the clarification had come up about a year back or 6 months back, where it says that whenever a resolution professional feels that it is important to convene a meeting, he shall do so. Or it can, on the basis of two scenarios that the IBBA has laid down, is that if the majority of the lenders, more than 33% feels that a meeting is required for discussing any particular reason, then he has to call for a meeting. So it is if any particular members where they have more than 33% voting rights say that you have to call for a meeting for any particular reasons, the RP cannot reject such request being made and has to convene a meeting. But if there is less than 33%, the RP may consider whether this request is necessary for calling upon a meeting or not. And if that is, and if he feels that he still feels that the meeting is required, then he'll call for a meeting. And during the meeting, each creditor shall vote in accordance with the voting share assigned to him based on the financial debt owed to such creditor. Now, once the CIP process starts, there is an appointment of a registered valuer. And why this registered value has been appointed to see what is the fair value and the liquidation value, because this liquidation value would have also noticed the language coming in under section 30, that at least I have to pay a liquidation value. So if tomorrow the company would have been wound up or liquidated, and the creditor or as an operational credit lease would be getting whatever value in accordance with the distribution under section 53, which is nothing but a liquidation value. So in order to determine the fair value and the liquidation value, an appointment happens. There is a two registered values are appointed, and that appointment is submitted to the estimate, and that is a voting reserve or voting requirement that whenever a registered value is being appointed, it has to be first voted upon. Here we had seen a very peculiar situation where there was a registered values, two registered values were appointed. Now those registered values had conducted their evaluation and submitted their reports. Now there are two questions of law that that we've seen that normally is part of the process, where whether a resolution plan can be opened in the absence of or resolution, sorry, a valuation report can be opened as and when the resolution plans are being submitted, or the resolution plans have to be in compliance with the regulation. So under regulation 35, what it says that as and when the resolution plans are submitted, the resolution professional can only open the valuation if the plans are in accordance with the provisions of the code and the regulation. What is the meaning of in accordance? So obviously in accordance is not defined anywhere, so you'll have to go back to your Blackstone dictionary. So accordance is nothing but it has to be in conformity with the provisions of the code. That is nothing but when an RP receives resolution plans, and as I just said that only the plans which are in accordance with the code can be put up for voting. In such situations, only when the plan comes in can be put up and can be the registered values can open or the valuation reports can be opened. Now, appointment of transaction auditor is nothing but just for an appointment or just to see whether any kind of avoidance transaction. There is section 43, which is preferential transaction, 45, which is extortionate or undervalued or fraudulent transaction has been taken place. There is kind of a look back period in a section 43, which says that if for a related party, it is 2 years, and for a non-related party is 1 year to see whether there is any preferential transaction. But very important that there is no look back period in the section 66. So if there is any kind of a fraudulent transaction done prior to that, and if a transaction auditor finds out that this is a fraudulent transaction, obviously as an RP in his wisdom will have to decide whether this application is required to be filed before the NCLT for any kind of a reversal, then he may do so by filing an application. Now, information memorandum, as I just said, that will deal with all the information that is required for the resolution of applicant to submit a resolution plan. Now, invitation for expression of interest is where a resolution, one of the duties, as I said, is that the resolution profession has to invite plans. And once plan comes in, I have to see the eligibility criteria. So he will do so on the basis of the eligibility criteria decided by the CoC. He'll issue a public announcement and will publish a Form G. And on the basis of Form G being published, the resolution applicants meeting the criteria, because it is the duty of the resolution applicant to see whether they are meeting the criteria or not. And on that basis, documents have to be provided to that extent. And once that has been done, the resolution plans have to be submitted in accordance with the provisions of the code. Now, eligibility of criteria is obviously section 29 is very important, that today you don't want a situation where, and this was specifically brought in by the legislature to avoid any promoter submitting resolution plan. because the whole purpose of the intent will get defeated if you are still allowing the promoter to submit the resolution plan. So here they had introduced section 29A that you are ineligible to submit a resolution plan, or for reasons may obviously given therein, that if you're an undischarged involvement. But here, if you're an MSME, your two of your criteria will not apply, which is if you're an undischarged insolvent, or if you have been convicted for any of offense punishable with imprisonment of 2 years. So an MSME can, as a promoter of an MSME, can submit a resolution plan in light of the amendment under the IBC. So resolution plans are nothing but a plan along with where you lay down your financial proposals to be made or to be paid to the creditors of the corporate debtor. So resolution applicant may submit a resolution plan along with an affidavit that is eligible under section 29A to the resolution professional prepared on the basis of information memorandum. The resolution professional shall examine each resolution plan. See, this is very important. Each resolution plan received by him to confirm that each resolution plan provides for payment of insolvency resolution cost, which will have priority. So your first payment has to be under the resolution plan towards the insolvency resolution process cost, which is nothing but the cost that has been incurred during the CIRP process to run the corporate debtor as a going concern. Then it provides for the payment of the debts of operation creditors in such manner as may be specified, which shall not be less than the amount to be paid to such creditors in the event of liquidation. As I just said, that why a valuation is being conducted to see that if the company would have been liquidated, how these creditors would have got money, and in that basis, that liquidation value has to be derived. Then resolution plans shall, once the resolution plans are verified, deliberated, there would be a several rounds of deliberation with the CoC and the resolution applicant, where obviously in most of the cases that we've seen, the resolution plan will be less than the liquidation value. But the Supreme Court or the NCLAT also has led that even if it is even if the value or the plan value is less than the liquidation value, if there is a genuine case of a company as a going concern, then the CoC in their wisdom in various judgment case, Shashidhar and all, can obviously approve the resolution plan, and NCLT cannot challenge such decision, and will only in the SR Steel judgment, the Supreme Court has also said that they have to only look into the four corners of the law. So once the resolution plan shall present to the CoC for his approval, such resolution plan which conform to the condition 2 in subsection 30 of the code and CRP regulation. The committee shall evaluate the plan strictly as per the evaluation matrix to identify the best resolution plan and may approve it with such modification as it deems fit, provided the CoC shall record his deliberation on the feasibility and viability. Because this is very important, that if, as I said, my resolution plans have to be feasible and viable. I don't want any person to just say that today I am making a payment, because in most of the cases your plan will be a deferred payment. Upfront payment will be somewhere about 15-20 to 20%, and other plans will be a deferred payment. So today you want to see whether the resolution applicant has the feasibility and viability to fulfill the terms of the resolution plan. The CoC may approve a resolution plan by a vote not less than 66% of the voting share after considering its feasibility, viability, and the manner of resolution proposed, which may take into account the order priority amongst the creditors. See, here under regulation 30, section 30, it says that it is the resolution applicant who will propose the distribution, and the CoC will deliberate on the distribution on the basis of the priority, and the priority can be in the manner of your security interest or value, which all depends upon on a case-to-case basis. And once the plan is being approved, the resolution plan shall submit the resolution plan to the adjudicating authority. If the adjudicating authority is satisfied the resolution plan is approved under subsection 4 of section 30 meets the requirement, they shall by order approve the resolution plan, which shall be binding on the corporate debtor and its employees and all other stakeholders. But if the adjudicating authority is satisfied that it does not conform to the requirement, it by an order reject the resolution plan and will go for liquidation. And lastly, just to deal once if the NCLT rejects the resolution plan under section 31 for the non-compliance specified therein, it shall pass an order requiring the CA corporator to be liquidated in the manner laid down under IB code and issue a public announcement treating the corporators in liquidation. And where the resolution preferred anytime during the CIP process, but before confirmation resolution intimates the adjudicating of the decision of the committee approved by not less than 60% of the voting share to liquidate, the authority shall pass an order for liquidation. So this is where we have seen that if today the company is not feasible or viable to sustain, like in one of our accounts, the company though had vessels, and as the company was dealing into vessels, and majority of the vessels were either used for the purpose of charter purpose given to the ONGC or were tugboats. So this company, no one was willing to take the company as a going concern, and people were inquiring to take the assets on an asset various basis on an individual level. So what the CoC had decided at that point of time was that there's no point in running the company as a going concern because we are not getting any interest to take the company as a going concern. So in that case, there was an early liquidation where the majority of the lenders decided to wind up the so liquidate and sell the assets on a standalone basis. So yeah, that's just from my side on the CIP process. Any question and answer, I'm happy to answer them.
We all look up to you, sir. Thank you for your informative and inspiring session. You have given us a very different perspective of this topic with your vast experience. And all of our attendees must have learned a lot from you. Thank you, sir.
Thank you so much for that.
Now we will be commencing with the question and answer round. Out of the questions collected in the registration form and the ones submitted to us live on the Zoom call and the YouTube live stream, a few are shortlisted. Sir, one of the questions we received is, what role does economics play in the insolvency laws?
What role does sorry, I didn't get your question.
Sir, what role does economics play?
It plays a lot. It plays a lot. So I'll give an example that we've seen in one of our recent accounts as well. Like you would have noticed in most of the cases where resolution process starts and there is a huge time gap between a process that starts and the process that ends. Like in SR Steel started in 2017, the plan was approved in 2020. You would have noticed that when SR Steel was obviously ordered to be initiated CIP proceedings, the steel prices had crashed. But when the IRP had taken over and the company was then performing well, there were returns which were far better than the company could have paid off. So obviously it depends. In one of our accounts where we've seen the company has a particular, there are resolution applicants who have submitted a plan which are far lesser than the liquidation value. But that value would have further gone down because of COVID. So it would have gone down because 15-20%. So it plays a major role in any resolution process, is what I feel.
So another question we received, it's a bit long. How does IBC deal with personal guarantors? Do you feel it's a fair way for repayment of loan? The rules do not provide a clear way forward for the personal guarantors. According to you, what is the recourse for the personal guarantors in such instances?
No, the recourse is already there. It's already there. So it's just, I see personal guarantee, frankly, that's my personal opinion. It's a sham. It's a sham transaction. It's just, and why the lenders insist upon is to basically just show the credit worthiness of that entity at the time of booking a loan. Because tomorrow, if you would have noticed, any personal guarantors obviously would, I would not name them, would have just siphoned off their monies through some here and there. So that account must be sitting in some Swiss account or some country which is tax haven country, and eventually there are no assets in India. See, at the end of the day, when I'm as a personal guarantor, I can take a personal guarantee which makes sense. Like for example, SR Steel, a debt of 50,000 crores, that person does not have any asset today to pay off, and you're taking a personal guarantee for what reason? You're not going to recover any money. It's obviously my liability, so it says that it's co-extensive or co-terminus. But today, if I as an individual does not have any asset to pay off, that this personal guarantee, even if you run after me, you're not in. See, their best recourse is already what IBC had done is that the company which is under IBC, instead of now running before DRT, they have to come before the NCLT, which is the best thing that could have happened because they are understanding the process which is there under IBC. But today, initiating any process again, personal guarantee is nothing but just a kind of saving your interest to say that I have taken action, but you will not be able to recover any money. Because most of the cases, the liability, these assets will be hardly anything.
Yes, sir. So another question that we received is, the voting power among the CoC depends on the amount owed to the particular creditor. So what if the resolution plan is approved by the CoC on virtue of more than 66% approval, but a particular creditor to whom the maximum amount is owed against resolution plan?
No, so if majority of the lenders had, so for example, just to understand the question, so there are 10 lenders, one lender has about 20%, having a majority of voting in terms of his share. But 9 of the lenders are voting in favor of the plan and that person rejects the resolution plan. What if the question is correct? But then the plan
Yes.
is the resolution, as I said, section 31, it is binding. If any plan is being approved on section C, he will go and challenge it. He said that I'm not getting anything. But as a CoC in the wisdom, they've decided the plan more than 60%, it is binding on all the stakeholders of section 31.
Thank you, sir. Thank you for asking the question, for answering the questions.
No problem,
I'm sure all of us learned a lot from you today.
I went a bit fast, but I had to cover the entire process, which is like, I could have gone and it cannot happen in like 50 minutes. So maybe, yeah, so we can have another session for that.
For sure, sir. Thank you so much.
No problem, anytime.
Now it would be my pleasure to hand over the mic to my co-moderator, Shreyas Malik. Over to you, Shreyas.
Thank you so much, Nikita. Thank you.
Thank you.
It is a great honor for us to have this. Thank you.
Same here. It's my honor to be part of it.
With this, we'd like to invite the second speaker for the day, Dr. Charu Mathur, ma'am. I'll start with the introduction from ma'am. Dr. Charu Mathur, ma'am, is an advocate on record at Supreme Court of India. She has played a very key role in not just shaping, reforming, but practicing GST as well as Insolvency and Bankruptcy Code 2016. Ma'am is the content curator for EBC Learning as well as SEC Online Journal. Ma'am is a rare combination of not just legal consultation and advisory, but an academic side too. We are honored and humbled to have you here, ma'am.
Good evening. I hope I am audible and visible both.
Yes, ma'am.
Right?
Yes,
yeah.
Thank
you so much for having me. So, and thank you for your introduction. So the topic which has been given to me is to speak to you about the impact of COVID on IBC, how IBC has impacted COVID and all. And you will just excuse me for my poor lighting. I am right now not in India. I am abroad and the daylight and all those things. So time zone is a little difficult for me right now. So coming on to that, I will just quickly share the screen with you, what I wanted to show you. One second, just give me a second. So right now, I would just like to, before I start with you that how COVID has impacted IBC and everything, there are certain facts and figures which you must keep in mind. So the first thing is India is the world's 5th largest economy. And this is the map that I'm showing you is of 2017. So here, as you can see, US, it's hold around 24.4% and India holds around 6.27% and so on and so forth. I will be sharing PPT with you, so that is not a problem. Now, when the COVID-19 stuck, right, it has affected each one of us very badly, right? Each one of us, I don't think there is even a single individual who says that I'm not affected by it, right? Either in the close family or friends or even otherwise. So there was some survey done between the people around for the people, and they said that during the first month of April and May, that individual income dropped as much as by 40%. There were times that people did not get any income. It is said that 30% of lawyers, they have left their practice. I'm talking about Supreme Court. And in Supreme Court, we have lost around 100 members, only the members, not talking about their families, to the COVID during the second wave. Now, if you talk about the household, so even in a normal household, they say that there is a decline of around 3 months worth of income. So you can see, even if at a small individual scale, it has hurt so badly. So you can think about how vastly, how badly it has hit the economy as a whole. So again, some facts and figures for you. This is from The Economist. And as a law student, if you want to pursue a career in insolvency laws or even otherwise, it is a good idea. It is a good idea to have a brief eye on the various numbers. So between April to June 2020, India's GDP, this was during the first wave and during the first stringent lockdown, that our GDP dropped to massive 24.4%. Then it further went on to fall at 7.4%. And ultimately, if you look in the real contraction in the India, in real terms, is almost 7.3% for whole of 2021 financial year. So this is just the GDP chart for over the years that I am sharing with you. Now coming back to the IBC. So what happened with the IBC? So at the first instance, what happened is they increased the threshold limit. So if you recall that initially the threshold limit for invoking IBC was merely 1 lakh rupees, and so NCLT was flooded with various cases, right? From operational creditors, financial creditors, and everybody was coming. So as a first step to discourage it was to increase the threshold limit from 1 lakh to 1 crore. So if you read the charging provision, which is section 4 of the IBC, it itself says that government can increase it anytime to 1 crore rupees. So on the 24th of March, government increased this limit from 1 lakh to 1 crore rupees. Now coming on to, so this was the ordinance which has come into the place. So this was the first step which was taken by the government to increase the threshold limit. So now you know the threshold limit is 1 crore rupees, and it has come out with the immediate effect. Now, when all these things were going on, there was how to mitigate the trouble of people, right? So what the government did in March 2020, it has come out with a moratorium on EMIs. But this was issued by RBI. It issued 2 circulars, first on 27th March and second on 23rd May, which permitted lending institutions, including commercial banks and NBFCs, to allow moratorium of 6 months of payment of installment in respect of all terms loan outstanding on 1st March 2020. Now, as a lawyer, you must be in a habit to do the fine print. I also had many people calling me, many clients coming and saying, "Ki ma'am, bahut acha ho gaya, now so we don't have to pay EMIs." So it is a very good thing that has happened. So I said, no, you need to sit and understand and read what the ordinance is saying. It is saying that it is putting you a moratorium only for not paying it for the 6 months. But during that time, interest pe interest lagta rahega. So ultimately, you will be paying much more than what you would be paying. It is true that immediately you don't have to pay anything. Immediately you don't have any recovery proceedings. But what will happen is eventually you have to pay much more. So this was the advice I gave to my clients. And many of them were just following which was just coming in the newspapers, which was just coming in the TV debates, that it is nothing ki hamara to loan dena nahi, 6 mahine ke liye, we can sit aram se. So what we suggested is whatever you can pay, you must pay. Otherwise, whatever is your loan amount, term in that 6 months period will be added. So as you are law students, you must understand this thing to read the fine print, right? Don't go by the narratives which is on the newspaper or even on the television. Use your own discretion. This is my first thing that I wanted to share with you. Now, coming on to the second thing which I wanted to show you is now then they come out with the ordinance on the 5th June. This is called Insolvency and Bankruptcy Code Amendment Ordinance 2020. Now, according to this ordinance, it suspended the initiation of fresh insolvency proceedings against the debtor companies for a period of 6 months up to the maximum of 1 year. So, and this ordinance suggested the intent of the ordinance as to prevent companies which are experiencing distress on account of COVID-19 pandemic from being pushed into insolvency proceedings and to exclude defaults arising on account of COVID-19 pandemic for the purpose of insolvency process under the IBC. Now, what did this ordinance do? See, the idea behind this ordinance was very noble, that the government realized that companies are in trouble, right? So, even when they have increased the threshold limit, yet people could have invoked, like 100 home buyers could have got collected, and they say that take this builder, take him to the insolvency, put him to liquidation. So government says that you cannot initiate any insolvency proceeding during this period. So this was the one thing which was being initiated. The idea behind this was to mitigate the loss, to mitigate the hardships which the companies were facing due to the pandemic, right? Now, with this, in the same ordinance, they included something known as Section 10A. Now, what does Section 10A provides? Section 10A provides that no application shall be filed for commencement of corporate insolvency resolution process against the corporate debtor, whether as a financial creditor or operational creditor, or even for the voluntarily winding up under Section 10 for a default arising on or after 25th March 2020 for a period of 6 months or for such period not exceeding 1 year as may be notified by Government of India. So the suspension period which was given was of 6 months, starting from 25th March 2020. So a lot of litigation came into the courts. What about the debts which have been started before 2021, before 25th March 2020? Will they also be suspended? So the clear answer was it won't be suspended. It will be there. So only for the debts, only for the disputes that you are raising before 25th of March 2020, that this option is available to you. So there have been a lot of cases which has come to various NCLT, which has come to even traveled up to NCLT, that whether this is retrospective or whether it is prospective. Likewise for threshold also, it was whether it is retrospective or whether it is prospective. So the court says that until and unless it is being said that it is retrospective, it is always assumed to be prospective in nature. So with this, the court said that it will be only prospective in nature. Now, with this, we move to the next slide. So if you read these two notifications, if you read the notification and ordinance together, you will find that there is no application can ever be initiated for initiation of insolvency proceedings under Insolvency Code. So if you read Section 10A, it says that for this period, you can never ever initiate the proceedings for initiation of insolvency proceedings. So this was the one aspect, the first aspect which was shared. So what is the meaning of word ever? So the relief which is provided is whatever default that has occurred during this period of 25th March to 25th March 2020 to 25th March, it was till October and later it was again extended. You cannot have any proceedings ever late. So whatever was the period of hardship during the pandemic, if there is a default and it falls within in the suspension period, then it cannot be filed ever. Right? So this must be absolutely clear to you that this is what we want to say in this particular case. Now coming on to the further that what is the impact, does pandemic has made insolvency and bankruptcy court, does it made it totally useless? As people say that either it will be flooded or there won't be any activities which will be going on. So after a lot of deliberation, like I have also spoken on the various forum on the same topic, and what we have realized is that Section 10A, right? It actually does not differentiate between payment default caused by the pandemic and payment default which may be committed by the corporate borrowers for some other reason. So what it has done essentially is it has given you a period of suspension, and during that particular period, if there is any default, it will not be liable to be filed in the NCLT, that the period of suspension will be applicable forever, right? As it has used the word ever within in the Section 10A of the definition. I'll just quickly show you one more thing. Just give me a minute. Actually, I had made one entire video on this insolvency, this particular ordinance when it had come. So I can just share the link with you in the chat box. So in your, whenever you are free, if you feel like watching it, where is your chat box? Yeah. So in this video, which the link I have shared, you can check out this video where I have dealt with Section 10A in depth. It was done immediately the next day when this ordinance had come. So now coming back to our provisions on IBC, so this is the net result is if the period is totally under suspension, then they cannot be raised, the case against them cannot be raised for the default during the suspension period. Now, this ordinance has also added one more thing, which is Section 66(2), which is respect of resolution professional. Now, Section 66(2) provides that in case during the suspension period, even the resolution professional, he cannot file an application before the NCLT. Right, so this is what is all about IBC and the COVID-19. And now let me tell you that what are the various issues which arose before the consideration for the courts and even before the general public. So the first question which I told you is regarding the regarding your retrospective and prospective. So law is absolutely clear on that if it is until and unless it is made specifically retrospective, the presumption is always it is a prospective one, right? So this is the one thing which you need to understand. Now thereafter, there have been many queries regarding whether this exemption period, now can this, whenever there is the query was that it is usually, it is very unclear from the language of the ordinance as to how the default during this 6 months period will remain so after exempted. Won't it give the leeway to the companies that they escape insolvency? So this was a topic of debate in many webinars. It was a topic of debate in many seminars also. And even in the courts that it has briefly arose. So in this case, the courts have also firmly held, right, that what was the purpose of enacting this ordinance, for what purpose it has been enacted. So the answer to this is to mitigate the troubles which was the industry was facing at that point of a time. So this limited default window which was given, right? So it was the limited window which was given to the people during this time is to mitigate the loss which the industry was facing. Then secondly, it is being argued that it is not fair to assume that firms have a like to make a default, or the firms which did not default in March 2020 would take advantage of this and make a default. So court says that that even the IBVI said that this is not what we have observed, that there will be a default because people would like to take advantage of this default period being given. Now, the next question was regarding the pendency. They said that because government has given a moratorium, so as soon as the moratorium will remove, it will be flooding of cases before NCLT, and looking at the poor infrastructure at NCLT, they will not be able to handle it. So in this case also, this prediction has proven to be false. There is no dramatic surge in the NCLT filing, right? As a practitioner there, I can say that I am not flooded with the cases on IBC. As much they were coming pre-COVID times, they are still there. Now the reason for this is that stakeholders, they will not sit idle, right, for a year to wait that now when this moratorium will go, we will take the companies to, or we will take the defaulters to the IBC. There are alternative efficacious remedies which are available. So they would use it to serve out the option and make the resolution outside the court. For example, like banks, they realize, okay, IBC is not open, but I can always make recovery under SARFAESI or Civil Procedure Code, or even under the Recovery of Debt and Bankruptcy Act 1993. So there were alternative methods which were available, and the courts, the lenders and the stakeholders, they exercise that. Right, so this is the one aspect that I wanted to tell you. One more important thing that has come out during the COVID period is something known as out-of-court settlements, right? So with the out-of-court settlements, right, it was there during the pre-COVID period also, right? So during this period also, people, they tried to allow people to make out of court settlements. So this is another important thing which has come out of this pandemic, that people, they try to settle out. One more important thing aspect that has come out is known as pre-packs, right? Or a package which is before matters goes to the court, before you go to the whole exercise. So pre-packages come where you decide that you are a buyer, you are a defaulter, and if I take you to NCLT, you have to go through all the stage. This is the solution I am expecting, I am giving to you. If it suits you, let us just finalize this. So this is again, pre-packs right now is available only to MSME sectors as an experiment, but it looks like that it will likely to be succeeded. From the various data that has been collected, that the recovery in the IBC matter is roughly around 36% of the debt that is outstanding, right? So this is all that I have to share with you on the impact of COVID on IBC, and now I'm open to take your queries.
Thank you so much, ma'am, for the enlightening session. Thank you, ma'am. Ma'am, on the basis of the questionnaire that was circulated, the audience has sent a few questions. So, on the first question that came was on the basis of the last statement itself, that if there is a haircut of 36% and that of almost around 70% and 36% is being recovered, then what should motivate people to take the recourse of IBC?
See, IBC, otherwise, if you look at any other method, right? IBC it is faster, it is time bound. That is the greatest benefit of IBC, right? Except for the few cases like which you see in the media every day, like JP, etc., it is taking long. But most of the matters they are able to resolve. And one must remember that the object of IBC is not to recovery. Idea is to circulate money in the system. So what used to happen during SICA era is your money is stuck, right? Creditor is one who is running after and debtor is sitting comfortably. I have got stay from BIFR. You cannot move. You cannot do anything to me. You can move heaven and earth. Mera kuch nahi hoga. But under IBC, what has happened that it is the creditor who is in the control, right? You are not able to run your company, you get out. I will get somebody else to run this company because it is my money which is invested here, right? Apart from that, if you look at any other person, you are saying that what motivates them for banks, like if somebody's 1,000 crore rupees is stuck, and if he is getting even say 360 crores or 350 crores rupees, at least that money is coming back in system. So I do agree that there is a lacuna in the system, but that is probably the best case scenario that we, sorry. Yeah.
Thank you so much, ma'am. Thank you. The next question is, ma'am, how much does the cross-border disputes are significant under the insolvency law?
See, cross-border insolvency is a big thing, and it will be, because with the very nature of the business that we are seeing, there are assets across the globe, right, of any company. And it will be a tax, just like people have created tax haven, so even to protect their assets. So they will always create in a country where they have a better, I will say, protectionist regime. So cross-border insolvency, it has to be acknowledged, it has to be there. And irrespective of whichever era you are, pre or post-pandemic, that has to be inbuilt in the system itself.
Thank you so much, ma'am. Ma'am, there's this question that how effective IBC has been in its 5 years or 6 years of journey, according to you, ma'am?
I think IBC has been really effective. At least now people are scared of creating a default. They know that whatever they are sitting comfortably for generations, they can be thrown out. If you look at the case of SR Industries, SR, nobody could have touched the Ruyas, right? And today they have been thrown out of their own company. Nobody could have touched JP, but now NBCC is taking over it. So it is a big lesson. There are haircuts, but at least money is being churned and coming back into the system. If you look at the small scale players like operational creditors, I can give you a few examples. Like there was this one of my clients, he has filed against this meat exporter, biggest meat exporter in India. He was not even entertaining them. So we sent them a notice as an OC. And in the next day, he said, Ki main de dunga, I will give you the amount. And finally, she filed her claim with the RP, and she got a good amount. Like she made a claim for around 1 crore 5 lakhs, and eventually she got 70 lakhs or so, which otherwise she was not able to get because she was living practically on getting debt from other company to service another company. So some relief is definitely there. But at the same point of the time, I would like to say that court should not interfere. Like in my opinion, if you take that Supreme Court's interference in JP matter was not called for under Article 32. If you look at the IBC, it has given a very clear scheme, very clear timelines. For us lawyers, it is not very happy situation ki we have to clear defect within in a 1 week. We are also ki aaram se karwa lenge types, right? So you need to have a timeline. That is the crux. That is what makes IBC so precious. But courts interfering left, right, and center is making it not work properly. This is a commercial courts should discuss. You have given an adjudicatory body, let it function, and let it function in a time-bound manner, and it will be doing far better job rather than constitutional courts interfering in it.
Thank you, ma'am. Ma'am, the next question is a little long. So, ma'am, the person asks, could you please educate on the difference between the look-back period under Section 66, subsection 1, and the twilight period under Section 66, subsection 2? And the second part is, does COVID has any impact on these periods?
Effectively, I won't say there is no period that is there except for the 66(2), which the ordinance itself provided, because everything was suspended. So even the application which is to be filed by a resolution professional has been suspended. So in nutshell, in long term, because the entire period has gone as if it was never there. So I don't think it will have much of the impact.
Ma'am, this is the last question. Ma'am, is there any case in your eyes that you believe is revolutionary for the insolvency and bankruptcy world?
Right. So to start with, the very first judgments that have come from the Supreme Court, in the case of ICICI Bank, that is revolutionary. Then the entire case history, if you look at SR, it is revolutionary. If you look at the Swiss Bank and then Pioneer Urban Tech, they all are revolutionary in one way or another. So in my opinion, IBC was formed in a record time, right? Entire code. So if you go through Justice Nariman's judgment, he will even point out that there have been grammatical errors. Like even for the default and/or hona chahiye tha, but they had written only and. So it cannot be that you should have a suit and arbitration, suit and or arbitration. So these kind of small hiccups are there. Like even when the court saw you cannot withdraw under Section 12. So court realized this is not a provision which is not required. So the court made it and the government implicated. Likewise, your Section 29A, where it was introduced because the court could find that there is a mischief. Now, when you have matters like these, then you need to go to the constitutional court. And even in the SR case, it was not that they had come under Article 32. Right? In the SR first, when the matter was instituted at NCLT Ahmedabad, first they approached Gujarat High Court at Ahmedabad. So on the first day, Gujarat High Court stayed it. Then on the later date, it realized that we should not interfere. And matter went to the NCLT Ahmedabad, then it traveled to NCLAT, then to the Supreme Court, the right procedure, right? Instead of just jumping the guns and running down to Article 32 or 226, that it should not be done.
Thank you so much, ma'am. Thank you. Ma'am, with this, we come to the end of this session. And
Thank you
it
so
was an
much.
honor having you, and it was a very enlightening session for all of us. We take back a lot of knowledge and information with us to ponder over and to learn. Thank you so much, ma'am.
Thank you, everyone, for having me. Good day. Stay safe. Bye-bye.
Thank you. With this, I'd like to pass over the mic to the faculty convener, LexCom, Mrs. Sonia ma'am, for the valedictorian session. Thank you, ma'am.
Thank you, Shreyas. Good evening, everyone. So we have come to the end of this 2 days national workshop on IBC 2016. I, Sonia Man, Assistant Professor, Vivekananda Institute of Professional Studies and convener of LexCom, take this opportunity to present a vote of thanks to our learned speakers, Mr. Dhrupad Vaghani, Legal Counsel at Economic Laws Practice, and Dr. Charu Mathur, Advocate on Record at Supreme Court of India. It is our immense pleasure that the guests have graced the technical sessions of the National Workshop. We have had the opportunity to learn a lot about this complex law, and I'm sure all the participants have taken down notes of the same. In all, it was such an informative session. Thank you, Dhrupad sir. Thank you, Charu ma'am, for such an informative session and for answering all the questions. In the end, special thanks to Ms. Priya Bhatnagar, Convener, Placement Cell, VSLLS, WIPS, and Ms. Hani Sharma, Co-Convener of Placement Cell for being there and making this workshop a success. Also, the student coordinators and student volunteers demand special mention for their profound efforts in organizing and coordinating the workshop. So thank you everyone for your time and efforts. Thank you.
Thank you so much, ma'am, for these motivating words.
Thank you, ma'am.
Thank you so much, Sonia ma'am. Thank you for all coordination.
Thank you, ma'am.
Thank you so much, everyone.
I would like you to please fill the feedback form before exiting the session for us to reflect on what we can improve in our events to come. Thank you and have a great day.
Additionally, this form would be used to mark attendance and provide certificates for everyone. It is mandatory to fill the forms for both days to get the certificate. Thank you. Now we'll continue for 1 more minute to manage the lag on the live stream, and then we'll end the meeting.
Thank you all the student coordinators of LexCom. It was a great workshop. Congratulations to you all.
Thank you, ma'am.
Thank you so
Thank
much,
you so
ma'am.
much, ma'am.
Thank you.
Thank you.
Ma'am, we on behalf of the entire team would like to thank for your belief and support. Thank you. Really means a lot to us.
All the best for all the future events. Thank you all.
Thank you.
Bye.
I hope everyone has filled the forms. Also, team, you all